Every incident writes a unique narrative. Every investigation seeks objective facts. Securing your legal rights, uncovering real justice.
Sir, we need to speak with you. May we come inside?
What's this about? I'm busy right now.
We received a report regarding your daughter's iPad. Some concerning files were uploaded to the cloud.
Her iPad? I don't know what you're talking about.
Sir, the service provider flagged the content and contacted us. We have a warrant.
This is a mistake.
It was an afternoon in January when that front door opened and the agent's body camera captured what was on the other side. A man in a blue t-shirt, confused expression, with a black girl in a floral dress standing behind him, holding a red cup with both hands. The way children hold things when they don't know what is happening, but can sense that something is wrong. The timestamp in the upper right corner of the recording read January 14th, 2025, 3:45 in the afternoon. It was an ordinary Tuesday. The girl had probably just come home from school, and ICE agents were at the door of her house because an iPad had given away her location without anyone, not her, not her father, not the agents themselves, having fully understood what that meant until it was too late. The story that led to that moment at the door began weeks earlier in a chain of events that mixed technology, bureaucracy, and the kind of institutional error that only becomes visible when it has already caused enough. Damage to no longer be ignored, an iPad, a location application, a tip that originated from digital information misread by people who had the authority to act on it, but not the care necessary to verify what they were actually seeing. That combination placed federal agents at the door of a family that had done absolutely nothing wrong, and the body camera that recorded the moment that door opened would become the central evidence in everything that followed. The man who opened the door was named David. He was American, born and raised in the same state where that house stood, married for 11 years, father of 2 children. The girl behind him was his youngest daughter, who was 7 years old that January afternoon, and who at that specific moment probably did not understand why there were uniformed men in front of her house looking at her father with that expression. David understood even less. He had arrived home from work less than an hour earlier, had helped his daughter take off her coat, had put water on to boil for tea, and was in the middle of a completely ordinary afternoon when the doorbell rang and the world outside his door turned out to be something entirely different from what he expected to find. What the agents were looking for was not David. It was not his daughter. It was a completely different person with no connection to the family whatsoever, whose whereabouts had been associated with that address through a chain of digital inferences that started with location data from an iPad and ended with a federal operation on a Tuesday afternoon in a quiet residential neighborhood. The problem was that the chain had failed at a fundamental point. The moment when someone should have verified whether the digital data corresponded to a real person at that real address before authorizing any action. That verification did not happen, and the result was recorded on the body camera with date, time, and the face of a 7-year-old girl in the background. If this is your first time on this channel, welcome. What this story reveals about technology, power, and the consequences of acting without verifying goes far beyond this specific case, and you are going to want to follow every section to the end. Hit subscribe right now and tell me in the comments, did you know that the location data from your phone or tablet can be used this way? Write yes or no down below. The body camera kept recording while David tried to understand what was happening at the door of his own home, with his daughter behind him and federal agents in front of him. That recording, which the agents wore on their chests as standard documentation protocol, would become, in the weeks that followed, the most important evidence in a lawsuit that would cost the people involved far more than any of them had calculated on that January afternoon. Because what the camera showed was not a well-executed federal operation that had found the wrong person by chance. What it showed was the result of a series of negligent decisions that should never have reached that door on that afternoon with that child caught in the middle. It had all started with a location-sharing application installed on an iPad that belonged to David's oldest daughter, who was 12 years old, and used the device mainly to do homework and watch videos on weekends. It was a common application, the kind parents install on their children's devices to know where they are, with a simple interface and a function that seems harmless, until the data it generates reaches the wrong hands and is interpreted by people who do not have enough context to understand what they are looking at. The application automatically synced the iPad's location with a linked account, and that account, for a series of reasons that the subsequent investigation would take weeks to fully reconstruct, had been associated with a profile that was on ICE's radar. The person ICE was looking for was named Rosa. She had entered the United States some years earlier on a temporary work visa that had expired and had remained in the country after its expiration without regularizing her status. There was a pending deportation order in the system, and when ICE received information suggesting that Rosa might be located through digital data associated with a certain profile, the agency authorized an investigation. Up to that point, the process had followed a recognizable logic, however imperfect. The problem began when the analysts responsible for interpreting the location data made an error that any additional verification would have immediately revealed. They confused the device with the person. David's daughter's iPad had been purchased secondhand through an online electronics resale platform about 8 months before that January afternoon. The seller was a distant cousin of Rosa who had wiped the device before selling it, or at least had attempted to. Some accounts and settings had remained partially linked to the original profile in a way that was not visible to whoever used the iPad day to day, but that appeared in data tracking systems as an active connection between the device and that profile. When ICE began monitoring the location data associated with Rosa's profile, what they found was the iPad signal, which at that point was in David's oldest daughter's backpack, going back and forth from school every day, spending weekends at the family's residential address. From the perspective of the analysts looking at that data on a screen, the pattern appeared consistent with someone living at that address. The location returned regularly to the same point. There was daytime and nighttime presence. There was the kind of regularity that tracking systems associate with a fixed residence. What the analysts did not do, and this is the failure that the subsequent legal process would place at the center of everything, was cross-reference that location data with any additional verification about who actually lived at that address. A basic public records search would have revealed that the house was registered in David's name. An American citizen. A utility records check would have shown the same. Any of the elementary steps that exist precisely to prevent this kind of error had been skipped, and no one in the approval chain had required them to be completed before the operation was authorized. The authorization for the operation was signed on a Friday. The agents were briefed the following Monday, and on the afternoon of Tuesday, January 14, 2025, a team of 3 ICE agents arrived at David's residential address with the operational conviction that they were going to the right place to find the right person. None of them had seen a photo of Rosa before arriving. None of them knew that the family living at that address consisted of a white man, his black wife, who was at work that afternoon, and 2 daughters, one 12 and one 7 years old. None of them had been informed that the link between the address and the profile they were investigating was based entirely on location data from an electronic device, with no additional human verification. David opened the door knowing none of this. He saw the vests, saw the uniforms, saw the expressions, and the first thing he felt was not fear, but genuine confusion, the kind that comes when the reality you are seeing does not fit into any context that makes sense. He had done nothing. His family had done nothing. He paid his taxes, had stable employment, had lived in that house for 6 years without a single incident, and yet there were federal agents at his door on a Tuesday afternoon with body cameras recording, and a 7-year-old daughter behind him trying to understand why her father had suddenly gone so quiet. What happened in the minutes that followed was recorded in every detail, and every detail would matter far more than anyone present in that moment could have imagined. The agents explained the reason for the visit in the technical and economical language that operations of this kind tend to produce, with no room for nuance, no opening for context. They were there in connection with an immigration investigation. There was a profile associated with that address. They needed to verify the status of all residents. David listened to all of this with that expression the body camera captured in detail, and that anyone watching the video later would immediately recognize as the expression of someone trying to process a reality that makes no sense. He was American. His family was American. He had bought that house, signed that mortgage, lived at that address for 6 years. The idea that there was an immigration investigation connected to his front door did not fit into any context available to him in that moment. What David did next was something many people in the same situation would not do, not out of lack of courage, but out of lack of knowledge about What is legally possible when federal agents are at your door? He did not step back. He did not invite the agents inside. He did not begin answering questions about the residents of the house or about anything else. He stood at the door, with his daughter behind him, and asked to see the documentation authorizing that visit. There was no search warrant. The agents had what the agency called an administrative order, an internal document that authorizes ICE agents to investigate suspected immigration violations. But that does not carry the same legal weight as a judicial warrant and does not authorize forced entry into a private residence without the resident's consent. That distinction between an administrative order and a judicial warrant is one of the most important and least understood in the context of ICE operations at private residences. An administrative order is issued by the agency itself, without review by an independent judge, and does not satisfy the Fourth Amendment. Requirements for entry into a home. A judicial warrant, on the other hand, is issued by a judge after an assessment of probable cause, and that one does authorize entry regardless of the resident's wishes. David did not know that distinction in technical legal terms that January afternoon, but he knew, by instinct and common sense, that he had the right not to let people into his home without a clear legal reason, and that is exactly what he exercised. The agents remained at the door for nearly 20 minutes. During that time, the body camera kept recording everything. David answered some general questions but refused to provide detailed information about the residents of the house or to permit entry without a judicial warrant. The 7-year-old daughter remained visible in the background for much of that interaction, moving between the entrance and the interior hallway with the red cup still in her hand, unaware of the details of what was happening, but clearly affected by the tension that had taken over the space that should have been the safest place in the world for her. At some point during those 20 minutes, David picked up his phone and called his wife, who was at work, and then a lawyer whose number he had saved for a reason that afternoon turned out to have been one of the best decisions he had ever made. The attorney guided David by phone in real time, while the agents were still at the door. That guidance was clear. Without a judicial warrant, David was not required to let the agents in, was not required to provide information about the residents, and was not required to answer questions beyond confirming his own identity. David followed that guidance with a composure the body camera documented precisely, and that would later be cited by his attorneys as evidence that at no point was there obstruction, at no point was there confrontation, at no point was there anything that justified the continuation of that operation at that address. There was only a father at the door of his own home, exercising constitutional rights that exist precisely for situations like that one. The agents withdrew after 23 minutes, according to the body camera's timestamp. They left without having entered the house, without having found the person they were looking for, and with a recording that documented every second of an operation that should never have reached that address. David closed the door, turned to his daughter, and tried to explain what had just happened in a way that a 7-year-old could understand without becoming frightened. That conversation, which he would later describe in testimony as one of the most difficult things he had done as a father, revealed something about the real cost of that institutional error that no legal document could fully capture, because poorly executed federal operations do not only affect adults who understand what is happening. They enter homes where there are children who will go to sleep that night carrying an image they should never have had. David's wife, Camille, arrived home less than 40 minutes after the agents left. She had left work immediately after her husband's call, driven above the speed limit for much of the way, and come through the front door still in her coat with her bag on her shoulder. The kind of hurried arrival that communicates before any word is spoken that something had changed in that house that afternoon. What she found was David sitting at the kitchen table with the attorney still on the phone, the youngest daughter watching television on the couch with a silence that was not the normal silence of an occupied child, and the oldest daughter in her room with the door closed and the iPad, that specific iPad, in her hand. Camille listened to the full account, sat in silence for a moment, and then said something that David would later describe as the phrase that defined the direction of everything that followed. She said that this could not simply end there. Camille had personal and profound reasons for reacting that way that went beyond that specific day. She had grown up in a family that had experienced unjustified police stops, had seen up close what happens when institutions of power treat certain people as suspects by default, and had developed over her lifetime a finely tuned sensitivity for recognizing the difference between a genuine mistake and a mistake that happens because certain types of verification simply are not performed when certain families are on the other side of the door. She did not yet know all the details about how the iPad had become the center of that operation, but she knew there was a body camera that had recorded everything, and she knew that recording needed to be preserved before any internal administrative process could make it disappear. The attorney who had guided David by phone specialized in civil law, not specifically in federal misconduct cases, but he had contacts, and one of those contacts was a firm in Washington that had litigated cases against federal immigration agencies before, and had developed through those proceedings a very precise understanding of where the agencies were vulnerable and where they had the capacity to defend themselves. When David and Camille's case reached that firm 2 days after the incident, the partners' reaction was immediate. They asked for the body camera recording before anything else, before discussing strategy, before talking about fees, before any other conversation. The recording first, because the recording was the foundation of everything. Obtaining the recording was not straightforward. The agency did not hand it over voluntarily. It required a formal request through the Freedom of Information Act, accompanied by a legal notice preserving all rights related to the incident and explicitly warning that any alteration, editing, or destruction of the material would be treated as obstruction. That notice was sent the same day the firm was retained, with a speed that the agency's attorneys certainly recognized as the signal that the other side knew what it was doing. The agency had 45 days to respond to the formal request. David and Camille's firm used those 45 days building the rest of the case, collecting evidence, reconstructing the chain of decisions that had led that operation to that door. The reconstruction of that chain revealed a problem that went far beyond the technical error with the iPad. There was a written protocol within the agency that clearly established the verification steps that needed to be completed before any residential operation could be authorized. That protocol existed precisely to prevent the kind of situation that had occurred at David's home, and it had been ignored in a documented manner at least 3 distinct steps in the approval of that specific operation. This was not a case of a non-existent or ambiguous protocol. It was a case of a clear protocol, available, known to those involved, and deliberately skipped, because someone at some point in the chain had decided that the location data was convincing enough to justify bypassing the confirmation steps. That decision, made in a room far from that house in that neighborhood, had placed federal agents at the door of an innocent family with a 7-year-old girl holding a red cup. When the recording finally arrived, after a bureaucratic battle that consumed more time than the 45 days allowed and required an additional court petition to force delivery, David and Camille's attorneys watched the complete video in silence in a conference room in Washington. After the file ended, the senior partner of the firm was quiet for a moment, and then said there were 2 elements in that recording that made the case particularly strong. The first was the absolute clarity with which the video showed there was no justification for that operation at that address. The second was the child, not because her presence was manipulative or would be used in a sentimental way, but because she made it impossible to argue that the operation had been conducted with the minimum care the law requires when federal agents approach a private residence. A child visible in the background throughout that entire interaction was the most silent and most powerful evidence that something had gone fundamentally wrong long before that January afternoon. The lawsuit was filed in federal court on a March morning, 47 days after the incident. The document was 62 pages long and named the agency, the 3 agents individually, the analyst who had interpreted the location data without additional verification, and the supervisor who had signed the operation's authorization, knowing or having reason to know that the confirmation protocols had not been followed. Each defendant was named for a specific and documented reason, with precise references to the points in the decision chain where their individual responsibility could be established. It was not a process built in anger or urgency. It was a document constructed with the methodical coldness of people who had spent weeks placing every piece in the right position before presenting the whole. The central allegations were 3. The first was Fourth Amendment violation, because the operation had been conducted without a judicial warrant and without the emergency conditions. The law recognizes as justification for dispensing with one. The second was serious operational negligence, because the approval chain had ignored established internal protocols that existed specifically to prevent operations based on unverified data. The third was documentable emotional harm caused to minors, an allegation the attorneys had included with specific evidence and that transformed the presence of the 7-year-old daughter in the video from contextual detail into a central legal element. That third allegation was the one that most concerned the agency's attorneys, because it was the hardest to refute with procedural arguments and the most likely to resonate with a jury in a way that transcended the technical details of the case. The agency responded to the lawsuit with the standard strategy that federal institutions use when they cannot deny the central facts, but are unwilling to acknowledge them. They argued sovereign immunity for the agency as an entity, qualified immunity for the agents individually, and attempted to frame the entire situation as a good faith error committed by professionals acting within the reasonable limits of their operational authority. The qualified immunity argument is a legal shield that protects government agents from personal liability when their actions, even if wrong, did not violate clearly established constitutional rights that any reasonable person in their position should have known. It is a high standard of protection, and in many cases it works, but it has a very clear limit, and that limit is precisely the point where David and Camille's attorneys had built the case most carefully. For qualified immunity to hold, the agency needed to argue that a reasonable agent in the position of those three professionals could legitimately believe their conduct was constitutional, but the internal protocol that had been ignored existed precisely because the agency had already acknowledged in its own documents that operations based exclusively on digital location data without additional identity verification represented a risk of constitutional violation. In other words, the agency itself had documented that it knew about the problem and had created a procedure to avoid it. When that procedure was ignored, the argument that the agents could not have known they were violating constitutional rights collapsed completely, because there was an internal agency document saying they should have known. That detail, the existence of the internal protocol as evidence of prior institutional knowledge of the risk, was the moment when the agency's attorneys understood they were on far more difficult ground than they had initially calculated. They had assumed they could frame the case as an isolated technical error, the kind of thing that happens in complex operations, and that courts tend to treat with some deference toward agencies. But the combination of the ignored protocol, the body camera showing a child, in the background throughout the entire interaction, and the detailed reconstruction of the decision chain that David and Camille's team had produced in the weeks before, the filing created a picture that was far harder to defend than a simple operational error. It was a picture of systemic negligence with human consequences documented on video. Conversations about a settlement began informally through intermediaries before the formal responses to the lawsuit were even fully exchanged. That early movement toward a negotiated resolution confirmed what David and Camille's attorneys already suspected, that the agency had made its own assessment of the video, the ignored protocol, and the minor children allegation, and had concluded that a public trial with those central elements presented before a jury was a risk the institution was not willing to take. What was not yet clear, and what the negotiations would take weeks to resolve, was whether the agency was willing to accept the conditions that David and Camille considered non-negotiable, because they had decided from the very beginning that any agreement that did not include real and permanent consequences for the people responsible for that operation was not an agreement worth signing. The agreement was reached on an afternoon in June, 5 months after that January Tuesday that had begun like any other afternoon, and ended with a body camera recording the face of a 7-year-old girl in the background of a federal operation that should never have existed. The negotiations had been long, and at several points had seemed close to collapsing, especially in the moments when the agency tried to preserve the jobs of the agents involved through internal transfers that would technically keep them in service while removing them from direct operational roles. David and Camille had rejected that solution with a firmness their attorneys described as absolute. A transfer was not a consequence. A transfer was problem management. And they had not spent 5 months in federal litigation to accept problem management as an outcome. The 3 agents who had appeared at the door that afternoon were dismissed from the agency as a condition of the agreement. The analyst who had interpreted the iPad data without performing the necessary verifications was dismissed. The supervisor who had signed the operations authorization without requiring that protocols be followed was dismissed with loss of service-related benefits, a consequence that, in the context of federal agency careers, is significantly more severe than simple termination. 5 people lost their jobs because of a second-hand iPad, a partially linked account that no one had verified, and a series of negligent decisions that had placed federal agents at the door of an innocent family on a Tuesday afternoon. The financial value of the agreement was never publicly disclosed due to a confidentiality clause the agency had insisted on including, and that David and Camille's attorneys had accepted, after ensuring that all non-financial conditions were fully met and publicly verifiable. But beyond the amount paid, the agreement included 3 institutional obligations recorded as binding conditions. The first was the complete and documented revision of the identity verification protocol before residential operations, with the implementation of at least 2 independent levels of confirmation that needed to be completed and recorded before any authorization could be granted. The second was the creation of a periodic external audit mechanism for these operations, conducted by an entity independent of the agency. The third was the incorporation of the case, with all the details of the failure and its consequences, into the mandatory training of all new analysts and operational agents. Camille gave an interview a few weeks after the agreement was signed. She had been the driving force behind the decision not to accept any exit that did not include real consequences, and had also been the person who had insisted that the institutional obligations be as central as the financial value in the negotiations. She said something in that interview that circulated widely in the weeks that followed, not because it was dramatic or inflammatory, but because it was precise in a way that captured something legal documents cannot fully express. She said the problem had never been the iPad. The iPad was just the mechanism. The problem was that someone at some point in that chain had looked at a residential address, seen a location pattern that could have belonged to anyone, and decided that verifying who actually lived there was not a necessary step. And she said that decision had a name, even if no one at the agency was going to admit it out loud. David returned to work the week after the agreement was finalized. The daughters went back to school. The oldest daughter's iPad was replaced with a new device, with a completely new account and no connection to any previous history, and the location application was uninstalled by a family decision that required little discussion. Life returned to the appearance of normalcy that had been interrupted that January afternoon, but with a permanent awareness that had not existed before, and that David described in testimony as the real cost of that incident, more lasting than any financial amount and harder to name than any legal violation. It was the awareness that the protection he had assumed existed around his family had turned out to be conditional in a way he had not calculated. The case entered the legal record as one of the first to establish specific precedent regarding the use of digital location data as the basis for federal operations at private residences. It was cited in legislative discussions about regulating the use of data by immigration agencies, and was referenced by digital rights organizations as evidence of the need for clearer limits on how data generated by personal devices can be used in government investigations. The body camera that had recorded everything that afternoon, the same equipment the agents had worn on their chests as standard protocol without imagining what that file would become, remained as public evidence viewable by anyone who wanted to see what happens when technology, power, and negligence meet at the door of a family that had done absolutely nothing wrong. Sometimes the camera meant to protect the institution is the same one that shows why it needs to be held accountable.
We got a call. You need to come with us for verification.
You need to leave. You have no warrant to be here.
I am recording this. Get your hands off him. That's assault.
2 ICE agents believed they held absolute authority. They possessed an address. An anonymous tip phoned in from a prepaid cell.
It was just past 6 in the morning when the pounding on the door broke the silence of that suburban home. Not ordinary knocking, the kind of pounding that does not ask permission, does not wait for an answer, that already communicates before a single word is spoken that whoever is on the other side did not come to talk. The man who walked to the door was still in his sleep clothes. He had not had coffee. He had not had time to process anything. And when he opened the door and found himself facing ICE agents in tactical vests carrying the energy of people who had arrived to execute an operation, the first thing he did was something none of them expected. He asked to see the warrant. There was no warrant. And what happened in the minutes that followed, inside that house, was recorded. The camera captured everything with a clarity that left no room for alternative versions, for misunderstandings, for defense narratives constructed after the fact. It was all there. Agents entering without legal authorization, hands being placed on a man who had committed no crime, the verbal resistance of someone who knew his rights and refused to surrender them, even with federal agents standing inside his own living room. The video began circulating before the sun had even fully risen that morning. The man being physically grabbed by an ICE agent inside his own home was named Marcus, and Marcus was not an ordinary citizen without resources, without knowledge, without anyone to call. Marcus was a chief of police. He had spent decades in public safety, had built an entire career within the structures of the very system now being used against him, and knew the law with the intimacy of someone who applies it every day. The irony of that moment, a police chief being physically restrained by federal agents without a warrant inside his own home, was so brutal that the first people who saw the video thought it was staged. It was not. It was completely real, and what made that situation even more explosive was the sequence of events that followed in the hours, days, and weeks after that morning, because the agents who entered that house without a warrant, who put their hands on Marcus without legal justification, who ignored every protocol they themselves were required to follow, had failed to calculate one fundamental thing, that the person they were approaching knew exactly what they were doing wrong, knew exactly how to document it, and had precisely the contacts necessary to ensure that no one would forget. If this is your first time on this channel, welcome. This story gets more intense with every section, and you are going to want to follow it all the way to the end. Before we continue, hit subscribe and tell me in the comments, do you believe this could happen to anyone, or does it only happen to certain people? Tell me down below, because that question matters deeply to what this story is about to reveal. The video from that morning became one of the most watched and most discussed recordings in the debate about federal abuse of power in the United States during that period. Not because it was the only case of ICE agents entering homes without a warrant, but because this time the person on the other side of the operation had a name, had a title, had decades of documented public service, and had a camera recording every second. And because when everything was over, the careers that were destroyed did not belong to the man being grabbed. They belonged to the ones doing the grabbing. Marcus had arrived in that city nearly 20 years before. He came young, with a criminal justice degree in hand, and a quiet determination that the people around him took a little time to recognize, but that never disappeared. He had started at the bottom, like any other officer, working night shifts in difficult neighborhoods, learning in practice what no classroom can fully teach about what it means to stand between the law and chaos. He had risen slowly, without shortcuts, accumulating respect in the way that can only be built through time and consistency. And when he was appointed chief of police, it had been unanimously the kind of decision that happens when no one in the room has a legitimate argument against it. The house where Marcus lived was the house he and his wife had bought 16 years earlier, when the neighborhood was still developing and the lots were more affordable. They had renovated slowly over the years, one room at a time, the way middle-class families build. There's spaces when there is no money to spare, but there is enough patience. It was an ordinary house, American suburb, with a lawn in the front and a 2-car garage. The kind of house that draws no attention, that blends in with the others on the street, that exists simply as the place where a family sleeps, eats, and begins and ends its days. There was nothing in that house that justified what happened that morning. ICE had received a tip. That was the official starting point of the entire operation. An anonymous report alleging that an undocumented individual was residing at that address. This kind of tip arrives by the thousands every month to immigration agencies, and the vast majority of them are investigated with some level of due diligence before any action is taken. There is a protocol. There is a verification chain. There is, above all, the constitutional requirement that federal agents obtain a judicial warrant before entering a private residence, unless there is an immediate and documentable emergency justifying warrantless entry. None of that was followed that morning. What the agents who arrived at that house at 6 in the morning did not know, or did not bother to verify, was the identity of the resident. A basic search in the system, the kind of check that takes literally minutes, would have immediately revealed that the address was registered in Marcus's name, that Marcus was an American citizen born in that state, and that Marcus held the highest position in the city's police hierarchy. That verification was either not done or it was done and ignored, and neither possibility is less serious than the other. Because if it was not done, it reveals an operational negligence that puts any citizen at risk who has the misfortune of being targeted by an anonymous tip. And if it was done and ignored, the problem is far more serious than negligence. The team that knocked on that door consisted of 4 agents, all uniformed, all in tactical vests with the ICE acronym in yellow letters on the back, all carrying the posture of people who had been briefed for a containment operation and not for a verification visit. When Marcus opened the door and asked to see the warrant, the response he received was not a legal explanation. It was pressure. The agents pushed forward, and when Marcus did not step back, when he held his ground at his own threshold and kept demanding legal documentation, one of the agents put his hands on him and attempted to push him further inside the house. That was the moment the camera captured most clearly. That was the moment that destroyed careers. What the agents did not know, as that entire scene unfolded in Marcus's living room, was that the person recording was not just a frightened family member trying to document an abuse out of instinct. It was Marcus's wife, a woman who had been married to a police chief for nearly 2 decades and who knew, with a precision that came from years of living alongside security, protocols, exactly what needed to be captured in that video for it to be useful afterward. She kept the camera steady. She made sure the agents' faces were visible. She made sure the interior of the house was visible, proving that the entry had occurred without authorization inside a private residence. Every second of that recording was, without the agents realizing it, evidence being built against them. The video lasted just under 4 minutes. 4 minutes that contained enough to end careers, open federal investigations, and put the name of that operation in the headlines of news outlets that the agents involved had probably never imagined would be covering a case like theirs. Marcus had been released that same morning after one of the agents finally ran the check that should have been done before anyone knocked on that door and discovered, with an embarrassing swiftness, exactly who the man was that they had just grabbed inside his own home. The operation was closed without any arrest, without any evidence of immigration irregularity, and with 4 federal agents walking out of that house in silence, knowing they had made a mistake whose dimensions were still becoming clear. Marcus did not spend the rest of that morning trying to emotionally recover from what had happened, though anyone in his position would have had every right to do so. He spent that morning on the phone. He called his personal attorney first, then the legal counsel of the police department, then 2 contacts he had built over decades of work in public safety who had direct access to federal oversight bodies. Each call was made with the same methodical calm Marcus had developed over years of handling crises. He was not panicking. He was building, brick by brick, the structure of a response that went far beyond a formal complaint. The video was sent to the attorney that same morning, accompanied by a written document prepared by Marcus's wife, detailing the exact sequence of events from the first sound of the pounding on the door to the moment the agents left. She had noted the times, had described each agent's appearance with enough detail for identification, had recorded every word she had heard clearly enough to be quoted. The document was 6 pages long. It was the kind of account that attorneys spend years trying to obtain from clients and rarely receive with that level of precision and detail. Marcus's wife had produced it in under 2 hours, while the memory of the agents was still fresh and her hands were still slightly trembling. When the attorney watched the video for the first time, he did something experienced lawyers rarely do right away. He said, without hesitation, that it was one of the clearest cases of Fourth Amendment violation he had seen in years of practice. The Fourth Amendment of the United States Constitution protects citizens against unreasonable searches and seizures, and requires that government agents obtain a warrant based on probable cause before entering a private residence. There was no warrant. There was no documented probable cause. There was none of the emergency conditions that the law recognizes as justification for entry without judicial authorization. There were only 4 federal agents who had decided, for reasons they would have to explain under oath, that the rules did not apply that morning. The question Marcus's attorney began investigating immediately was not just what had happened, but why it had happened. The anonymous tip was the official starting point, but anonymous tips arrive every day and do not result in tactical pre-dawn operations without prior identity verification. Something had failed in the chain of command that authorized that operation, and identifying exactly where that failure had occurred was fundamental to determining the scope of legal responsibility. Because in cases like this one, responsibility rarely ends with the agents who knocked on the door. It travels up the hierarchy until it reaches whoever approved the operation, without ensuring that minimum protocols had been followed. The video leaked to the press before any official investigation was announced. It remains unclear exactly how that happened, whether it was a strategic decision by Marcus's legal team, whether it was someone within the oversight structures who felt the public had a right to know, or whether it was simply the inevitable result of a video of that impact existing on multiple devices simultaneously. What is clear is the effect the leak produced. In less than 24 hours, those images of an ICE agent with his hands on a black chief of police inside his own living room had been seen by millions of people, and the reaction was not one of disbelief. It was one of recognition. The quiet, heavy kind of recognition that comes when something you already knew was happening is confirmed on screen with unusual clarity. The official investigation was announced 48 hours after the video leaked. It was not a voluntary decision by the agency. It was a response to pressure, the kind of institutional movement that happens when silence starts costing more than transparency. The ICE Internal Oversight Office released a brief statement confirming it was aware of the incident and that a review of operational procedures was being conducted. The statement did not mention Marcus by name. It acknowledged no error, it contained no word of apology or recognition of what had been done. It was the kind of institutional communiqué designed to look like a response without actually being one, the kind that experienced attorneys read in 30 seconds and immediately understand means the battle will be long. Marcus's legal team had anticipated exactly that response. They had already prepared the filing of a federal lawsuit even before the official statement was released, working in the hours following the video. Leak with a speed that is only possible when you have absolute clarity about the strength of what is in your hands. The lawsuit was officially filed in federal court 3 days after the incident, naming all 4 agents individually, the supervisor who had authorized the operation, and the agency itself as an institution responsible for the systemic failure that had made that morning possible. It was a dense document, technically precise, and constructed in a way that closed each of the exits the defense typically uses to create doubt in cases of federal misconduct. What made this lawsuit particularly difficult to defend from the agency's standpoint was the combination of elements that rarely appear together in a single case. There was the video, which was irrefutable. There was Marcus's impeccable record, which eliminated any attempt to construct an alternative narrative about who he was or what he had done to deserve that approach. There was the complete absence of a warrant, which transformed the agent's entry into a clear and documented constitutional violation. And there was the fact that the anonymous tip that had started everything had never been verified by any means before the operation was authorized, which meant that protocol had been ignored, not by a single agent acting on his own, but by an entire chain of decisions that would need to be explained. The 4 agents were removed from operational duties during the investigation. That removal was officially presented as a standard administrative measure, the kind of thing that happens automatically while facts are being established. But everyone who understands how these structures work knew that suspension during a federal investigation, in cases with video evidence, rarely ends with a return to service. The agents hired private attorneys, separate from the lawyer the agency had designated to represent institutional interests, which was itself a clear signal that they understood their interests, and the agencies were not necessarily the same. Each began constructing their own version of events, and the versions were not consistent with each other. The supervisor who had authorized the operation was a man named Reeves, with 15 years of service and a record that, when it began to be scrutinized by the investigation, revealed a pattern that no one inside the agency claimed not to have seen before, but that no one had ever formally documented. There were other operations authorized by Reeves with insufficient identity verification. There were other residential entries with questionable warrant documentation. There were filed complaints that had never been seriously investigated, the kind of history that exists in silence within institutions until a case large enough forces everyone to look at it. Marcus's case was large enough, and Reeves's record was now being examined by investigators who had no interest in protecting him. Public pressure kept growing while all of this was happening behind the scenes. Civil rights organizations had formally entered the case as interested parties. Legislators from both parties had made public statements demanding explanations, which in a political climate normally divided on immigration issues was itself revealing about how indefensible that specific operation had been. It was not possible to frame what had happened as a matter of immigration policy, because what had happened had nothing to do with immigration. It had to do with 4 federal agents entering an American citizen's home without a warrant, placing their hands on him without legal justification, and only backing down when they discovered who he was. That was the case. And that case had no political side. It had only one legal side, and that side was completely clear. The depositions began 6 weeks after the federal lawsuit was filed. This is the moment in a legal battle where the narratives constructed by defense attorneys meet the reality of questions asked under oath, and where the distance between what was said publicly and what actually happened frequently begins to collapse in ways that no communication strategy can contain. The 4 agents were deposed separately, in a deliberate sequence that Marcus's team had planned carefully, beginning with the agent who had placed his hands on him and progressing through the chain of command until reaching Reeves. Each deposition created a record that the next one needed to be consistent with, and consistency was exactly what that chain of command could not produce. The first agent to be deposed spent 3 hours answering questions about the events of that morning. His initial version was the rehearsed one, that the operation had followed protocol, that entry into the residence had been voluntary on the part of the resident, and that the force used had been minimal and justified by the resistance encountered. Each of those points was then confronted with the video, frame by frame, second by second. Marcus's attorney had prepared a detailed technical analysis of every moment in the recording, with precise timestamps and objective descriptions of what was happening in each frame. When the agent's version and what the video showed diverged, which happened repeatedly, the attorney simply stopped, pointed to the specific timestamp, and let the silence do the work. The second agent contradicted the first on 3 fundamental points. Not dramatically, not in a way that seemed intentional, but in the way contradictions emerge when 2 people are trying to recall a version of events that does not correspond to what actually happened. Small differences in sequence, discrepancies about who had made which decision and at what moment, incompatible versions of what had been said before entry into the residence. Each contradiction was documented by Marcus's attorneys with the quiet precision of people who knew they were building something that would be very difficult to dismantle later. The third and fourth agents deepened the contradictions rather than resolving them. Reeves was the last to be deposed. He arrived with 2 attorneys, one designated by the agency and one he had hired privately at his own expense, which communicated before any word was spoken that he understood the gravity of his position. His answers were carefully calibrated, the kind of testimony that is clearly the product of many hours of preparation with experienced lawyers. He acknowledged that he had authorized the operation. He stated that he had relied on the information provided by the team that had received the tip. He denied having known that the identity verification protocols had not been followed, and when confronted with the history of other operations with questionable documentation, he responded that each case had been handled according to the information available at the time, a phrase designed to sound reasonable while admitting nothing. What Reeves had not calculated was the volume of internal documentation that Marcus's team had obtained through formal public records requests, internal emails, operational reports, communication records between the agents and the supervisor in the hours before the operation. This material had been requested through the legal mechanisms available in this type of proceeding, and the agency had attempted to block part of the access by citing operational security concerns. The judge overseeing the case had rejected most of the blocks, determining that procedural transparency prevailed over institutional objections when there was prima facie evidence of constitutional rights violations. The material that reached Marcus's attorneys contained enough to transform what was already a solid case into something the agency simply could not defend in a public trial. Settlement negotiations began discreetly, through indirect channels, before the depositions were even fully completed. This is always the signal that the party being sued recognizes, at some level, its attorneys are not yet authorized to admit publicly that a trial would be worse than any agreement that could be negotiated now. The agency had an interest in avoiding a trial for reasons that went far beyond Marcus's specific case. A public trial with that video as the central evidence, with the contradictions between the agent's testimonies exposed before a jury, with Reeves's history being presented in detail, would create a precedent and a public record that would affect the agency far beyond that one case. Marcus knew this. His attorneys knew this, and they had no interest in facilitating an exit that did not fully reflect what had been done. The agreement was announced on a Thursday morning, 4.5 months after that 6 o'clock operation that had started everything. The figures were substantial, the kind of amount that federal agencies rarely agree to pay without a very clear awareness that the alternative would be worse. But Marcus had made it clear from the beginning, through his attorneys and at every moment of the negotiations, that money was not the center of what he was seeking. He had spent decades building a career dedicated to the idea that the law applies equally to everyone, that no one is above the protocols that exist to protect citizens from abuses of power, and that accountability is not optional when there is sufficient evidence that something wrong was done. He was not willing to accept an agreement that did not reflect that idea in a concrete and permanent way. The non-financial conditions of the agreement were, in many respects, more significant than the amount paid. The 4 agents involved in the operation were dismissed from the agency with no possibility of rehire in any federal law enforcement capacity. Reeves lost not only his job, but the certification he had accumulated over 15 years, which in practice ended any possibility of continuing a career in public safety at any level. The agency was required to implement a revised identity verification protocol before any residential operation, with multiple levels of confirmation that needed to be documented before any authorization could be granted. And Marcus's case was formally incorporated into the mandatory training material for new agents, not as an abstract example of what not to do, but as a specific case with names, faces, and real consequences. Marcus held a press conference the day after the agreement was announced. He appeared in uniform, which was a deliberate and meaningful choice. He was there not only as the victim of that specific incident, but as the chief of police of that city, representing an institution that had as much interest as any citizen in ensuring that federal agents operated within the boundaries of the law. He spoke for just over 10 minutes, without notes, without a teleprompter, with the direct clarity of someone who had thought deeply about what he wanted to say and had arrived at the essential. He said the agreement was not a personal victory. It was an obligation fulfilled. What Marcus said at that press conference about the video continued to be quoted in the weeks that followed in discussions about transparency and accountability in federal operations. He observed that the recording his wife had made that morning had not changed what had happened. The agents had still entered without a warrant. Hands had still been placed on him without legal justification. The abuse had still occurred. What the video had done was make it impossible to deny that it had occurred, and that distinction between what happens and what can be proven to have happened was the center of everything. Because without that recording, the agency's version would likely have prevailed, as it prevails in countless cases, where there is no camera, no witnesses with sufficient credibility, and no one with the resources necessary to sustain a legal battle against a federal agency. The dismissed agents disappeared from public view with a speed that contrasted with the impact the case had caused. There were no statements, no interviews, no public attempt to present an alternative side of the story. Their attorneys had clearly advised them that silence was the only reasonable strategy available, and they followed that advice. Reeves attempted, through the union representing federal agents, to reverse part of the conditions of his dismissal, arguing he had been treated disproportionately for a decision made in good faith with the information available. The argument did not survive the first levels of review. The information available had included a functioning camera near the neighboring community mailboxes and a federal database with Marcus's name and title 1 click away. Good faith had a very clear limit there. What this case left as a permanent record goes beyond the careers ended and the settlement paid. It entered the legal literature on Fourth Amendment violations in immigration operations. It was cited in congressional hearings on federal agency oversight. It became one of the most referenced examples in discussions about what happens when power meets no informed resistance, when people who should know the law decide it does not apply to them in that specific moment, and when the only thing separating impunity from consequence is a camera in the right hands. Marcus returned to work. The department he led continued to function, and in that suburban home, where everything had begun at 6 a.m. on an ordinary day, life moved forward with the quiet awareness that things could have ended completely differently if any one of the elements of that specific equation had been different. That awareness, uncomfortable and necessary, is probably the most important thing this case produced.
Excuse me, what exactly are you doing in this neighborhood?
I'm sorry, what? I'm just walking to my car.
Don't act dumb. This is a private community, and I know you don't belong here.
Ma'am, this is a public street. I live 3 houses down from here.
I'm calling the police. You are way too suspicious.
You're free to call whoever you...
It was a quiet Saturday morning in the neighborhood. The kind of morning where the silence of residential streets is only broken by the wind carrying autumn leaves across the sidewalk. Cars sat in driveways, houses were still, and everything had that deceptive appearance of a place where absolutely nothing could go wrong. It was October 14th, 2023, exactly 11:23 in the morning, and a security camera installed near the community mailboxes was recording everything in high definition, with no one around yet understanding the weight that footage would carry in the weeks to come. Diana had just returned from a yoga class. She was in workout clothes, carrying her rolled purple mat tucked under her arm, and was heading to the mailboxes the way she did every week. There was nothing extraordinary about that moment. She lived there, paid her HOA fees on time, and had the key to the box with her own house number engraved on it. She was a resident like any other in that neighborhood. But when a neighbor appeared, a blonde woman in a denim jacket with her arms crossed and an expression that left little room for ambiguity, what should have been an ordinary morning turned into something neither of them would ever forget. The neighbor approached with the posture of someone who had already made up her mind before she even opened her mouth. There was no friendliness, no casual greeting that you'd expect between people who had shared the same neighborhood for months. There was only that tense, accusatory energy, the kind that any black person who has ever lived in a predominantly white space recognizes immediately. It doesn't need to be spoken out loud. It lives in the body, in the gaze, in the way someone treats you as though you need to justify your presence in a particular place simply by existing there. Diana knew that energy. She had felt it before. And she understood, in that exact moment, that she needed to choose very carefully how she was going to respond. What the neighbor didn't know, and this is the detail that changes everything in this story, is that Diana wasn't just a resident of the neighborhood. Diana was a lawyer, not just any lawyer. She was a specialist in real estate law, a field that deals precisely with property, ownership, housing rights, and everything surrounding the legal space a person has the right to occupy. In other words, the woman being questioned about whether she actually lived there spent her weekdays defending other people's rights to their own properties. The irony was almost impossible to believe. Before we go any further, I need to ask you something. If this is your first time on this channel, welcome. This story gets far more intense than these first few minutes suggest, and you are going to want to stay until the end. Hit subscribe right now and tell me in the comments if you have ever been through something like this. If you have ever been treated as though you didn't belong somewhere, you had every right to be. It could be a neighborhood, a store, a hotel, a restaurant. Tell me down below, because this conversation matters. The security camera kept recording as the two women stood there on the sidewalk near the mailboxes, autumn leaves behind them and the cloudy October sky above. Within minutes, that footage would stop being just a file in a residential monitoring system and become evidence. Evidence of something that happens with alarming frequency in neighborhoods, shopping centers, elevators, and streets across the country, but that is rarely captured with such clarity. And when that video reached the right hands, the life of one of those two women on that sidewalk would never be the same again. Diana grew up understanding that competence was not enough, that diplomas on the wall were not enough, that an address in a good neighborhood was not enough. She had learned this not in a classroom, but through life. Through the small daily humiliations that accumulate in silence over the years and shape the way a black person learns to move through the world. She had built her career with an almost stubborn discipline, spent years studying real estate law, built a solid reputation, and bought her home in that neighborhood not by chance, but because she had worked for it with a determination that most people would never need to have. And yet, there she was, on the sidewalk, being questioned. The neighbor who approached that morning was named Susan. She had lived in the neighborhood for several years and had apparently developed over that time a kind of ownership over the surrounding space. The territorial comfort that certain people build without ever realizing it rests on the assumption that some people belong and others do not. Susan was not, at least on the surface, what most people would picture when they think of someone racist. She did not shout. She did not use slurs. She simply walked up to a neighbor who was checking her mail and began asking questions in a tone that made clear these were not real questions at all. They were demands dressed up as curiosity. What makes this kind of situation so devastating is not obvious violence. It is exactly the opposite. It is the way everything unfolds in a controlled tone of voice, in language that sounds reasonable on the surface, but carries underneath it an absolutely clear message. Prove that you have the right to be here. This dynamic has a name. Researchers and behavioral specialists call it everyday racism or microaggression. But the technical term fails to capture the real weight of what it is to be on the receiving end of that experience. It is not micro for the person living it. It is exhausting. It is humiliating. And it happens with a frequency that people who have never experienced it simply cannot imagine. Diana stood there listening to Susan's questions with a calm that anyone who knew her would understand came at a cost. She was a lawyer. She spent her days navigating conflicts, negotiations, situations where keeping composure was the difference between winning and losing. But there is an enormous difference between maintaining composure in a conference room or a courtroom, and maintaining composure when someone is treating you like an intruder in the place where you sleep, where you keep your things, where you have the absolute legal right to be. Even so, she did not lose control. She responded. She explained. And at some point during that exchange, she did something Susan certainly did not expect. She made it clear that she knew exactly what her rights were. Have you ever stopped to think about how many times a day Black people have to make that calculation? How far do I go? How much do I explain? When do I stop justifying myself? It is not a simple decision. There are consequences in every direction you choose. If you back down, the situation repeats itself because it went unpunished. If you respond too firmly, you become the problem. If you draw attention to the injustice, you are told you are overreacting, that you are being sensitive, that you are seeing racism where none exists. It is a trap designed to have no exit, and Diana knew every corner of it. What Susan had not calculated, not for a single moment as she stood there with her arms crossed, asking her questions on that October morning, was that the security camera positioned near the mailboxes was capturing everything. Every second of that interaction was being recorded with the date and time stamped in the upper right corner of the frame. And what the camera showed was not an ambiguous situation open to interpretation. What it showed was one woman approaching another in a shared public space with no legitimate reason, with body language that told a very specific story about what she truly thought about having Diana as a neighbor. That footage was about to become the center of everything. When Diana walked back into her house that morning, she did not go straight to the kitchen to make coffee or turn on the television the way she would have on any other normal Saturday. She sat down. She was quiet for a moment. And then she began to process what had just happened with the analytical mind of someone who spends their professional life dismantling situations and identifying what is truly at stake. She knew that what Susan had done was not just unpleasant. It was potentially illegal, and she knew, with the precision of someone who understands the law from the inside, exactly which paths were available to her in that moment. The first step was to check the security cameras. The neighborhood had a monitoring system in common areas, including the mailbox area, and Diana knew this. She had noticed the cameras before, the way people who pay attention to their surroundings tend to notice these things. When she confirmed that the camera was positioned directly over the location where the conversation had taken place, she understood that she had something concrete. It was not just her word against Susan's word. There was a recording. There was an objective record of that moment, with date, time, and image clear enough to show exactly what had happened and how it had happened. Getting access to that recording was not immediate. It involved contacting the neighborhood association, making a formal request, and navigating the bureaucracy those requests typically entail. But Diana was a lawyer. She knew how to make formal requests. She knew what her rights were as a resident regarding access to recordings from common areas. And she knew that every hour that passed without that file being preserved was an hour in which it could be overwritten or deleted by the system's automatic rotation. She acted with urgency, but with method. No agitation, no confrontation, just the quiet efficiency of someone who knows exactly what they are doing. While she waited for the footage, Diana began documenting everything she could. She wrote a detailed account of the conversation, while the memories were still fresh, noting not just what was said, but the tone, the posture, the sequence of events. She photographed the mailbox area. She identified which neighbors might have seen or heard anything. This documentation process might seem excessive to anyone who has never had to prove they were the victim of something that leaves no physical marks. But Diana understood that in situations like this one, where discrimination happens in carefully controlled language and without obvious witnesses, the difference between being able to hold someone accountable or not almost always comes down to the details most people dismiss as irrelevant. The video arrived, and when Diana watched that footage for the first time, sitting in front of her computer with the file finally open on the screen, what she saw confirmed everything she had felt on that sidewalk. The camera had captured Susan's approach with unsettling clarity. You could see the body language, the crossed arms, the expression on her face, the way Susan had positioned herself in relation to Diana in a manner that anyone watching would recognize as confrontational. There was no ambiguity in those images. There was no way to watch that video and conclude that what was taking place was a friendly conversation between neighbors. What was happening there was an interrogation, and the reason for that interrogation was implicit in every second of the recording. Diana sent the video to several professional colleagues that same evening, not to ask for their opinion about what had happened. She already knew what had happened, but to assess, with other trained eyes, what the smartest strategy would be from that point forward. The responses were unanimous. What the footage showed was sufficient to support a formal complaint with the Neighborhood Association for Racial Discrimination, and possibly far more than that. One colleague who watched the video said something that stayed with Diana for days, that Susan had made the classic mistake of people who act on prejudice and have never been held accountable before. She had acted as though there would be no consequences, as though no one was watching, as though the entire world could not see. The formal complaint was filed on a Monday morning, 2 days after the incident. Diana arrived at the Neighborhood Association's management office with a carefully drafted document, the detailed account she had written on Saturday, and a preserved copy of the recording. The person who received her on the other side of the counter clearly had not expected that level of preparation. They had not expected precise legal language, had not expected specific references to the clauses in the neighborhood's internal regulations, prohibiting discrimination among residents, and had definitely not expected the woman sitting across from them to know exactly what the management's legal obligations were from the moment a formal complaint was registered. The meeting was brief, the complaint was accepted, and the clock began to run. The Neighborhood Association contacted Susan that same week. What was said in that conversation was never fully disclosed, but the result was clear. Susan received a formal notification informing her that a complaint had been filed against her for discriminatory conduct, and that the association was obligated to investigate. For Susan, this was likely the first moment in which the seriousness of what she had done began to take any concrete form. Until then, from her perspective, what had happened on that sidewalk was simply a conversation between neighbors. Perhaps uncomfortable, perhaps misinterpreted, but not something with real consequences. The formal notification was the first indication that she had miscalculated badly. Susan hired a lawyer. This detail matters because it reveals something about how she interpreted the situation. She did not go to Diana to apologize. She did not go to the Neighborhood Association to try to resolve the misunderstanding, as she surely would have called it had she had that conversation. She went directly to a lawyer, which means that on some level, she knew she had done something that required a defense. Her attorney began constructing the narrative that was predictable from the start, that Susan was simply being a good neighbor, concerned about the safety of the community, that there had been no discriminatory intent, that everything had been misinterpreted by Diana, and that the formal complaint was a disproportionate reaction to a completely ordinary situation. That defense narrative, the one about the concerned neighbor looking out for community safety, is one of the oldest and most commonly used in cases of racial discrimination in residential communities. It works because it sounds reasonable on the surface. Who could be against neighbors who care about the safety of the place where they live? The problem is that it collapses completely when you ask the right questions. Why was Diana specifically approached and not other residents who were in the area at the same time? Why was the approach immediately confrontational rather than friendly? Why had Susan never approached Diana in this way? Before, during the weeks the two had coexisted in the neighborhood without incident. And most importantly, Why was the body language captured in the recording consistent with suspicion and hostility rather than genuine concern? Diana's attorney responded to the defense narrative with something far more powerful than counter-arguments. With evidence. The footage was analyzed frame by frame. Experts in nonverbal behavior were consulted to technically document what anyone watching the video already perceived intuitively. The history of the neighborhood association was researched for other similar incidents, other complaints, other patterns that could contextualize what had happened to Diana, not as an isolated event, but as part of something larger. Every piece of information that Susan's defense presented was found, examined, and answered with surgical precision. Diana was not merely reacting, she was building a case. What was becoming increasingly evident as the process moved forward was that Susan had underestimated Diana in a way that went far beyond that Saturday morning. She had underestimated her knowledge, her determination, and her capacity to transform that humiliating experience into a legal battle that Susan was simply not equipped to win. There is a particular cruelty in discriminating against someone who has dedicated their professional life to understanding and defending the very rights being violated in that exact moment. Susan had chosen, for reasons only she could explain, to confront precisely the wrong person. And now, the consequences of that choice were beginning to take shape in a way that neither of them could ignore. The legal process that followed lasted months, and during those months Susan's life continued apparently normal on the outside, while on the inside it was being systematically dismantled by a body of evidence she had no way to refute. Her attorney did what defense lawyers do in these cases, tried to create doubt, tried to recontextualize what the camera had shown, tried to convince the parties involved that all of this was a monumental exaggeration about a trivial conversation between neighbors. But there is a very clear limit to what arguments can accomplish when a high-definition recording exists, showing exactly the opposite of what the defense is trying to sustain. The recording was the center of everything throughout the entire process. It was formally presented, analyzed by experts, and displayed in contexts that Susan had certainly never imagined when she stood there with her arms crossed on that October morning. Every frame of that video told a story that required no narration. The way Susan had approached, the posture she had maintained throughout the conversation, the expression she wore on her face while Diana answered her questions with the exhausted calm of someone who had been through this before. All of it was there, digitally preserved, irrefutable. And the more Susan's attorney tried to find a way to reinterpret those images, the more evident it became that no reinterpretation was possible. What the process also began to reveal, as it moved forward, was a history that made the incident even less isolated than it had already seemed. Other residents of the neighborhood, most of them black or from other minorities, began sharing their own experiences. None of them had ever filed a formal complaint, for reasons that anyone who understands how these dynamics work recognizes immediately. The fear of not being believed, the exhaustion of having to repeatedly prove what you know happened, the feeling that the system was not built to protect you. But when Diana opened that space by filing her complaint and making the process visible, those stories began to emerge, and they painted a picture far broader than a single incident on a Saturday morning. The neighborhood association, which had initially treated Diana's complaint as a bureaucratic problem to be managed, began to realize it was sitting on top of something potentially far more serious. A documented pattern of racial discrimination in the common areas of a residential community is not merely a neighbor relations problem. It is a legal liability. It is the kind of thing that results in lawsuits not just against the individual who practiced the discrimination, but against the entity that manages the space where it happened and that failed to create a safe and equal environment for all its residents. Diana's attorney had made this very clear from the beginning, and now the association was finally taking it seriously. Susan received a settlement offer several weeks before. The case was set to go to trial. The initial figures were rejected by Diana, who was not conducting this process in search of whatever amount would make the problem quietly disappear. She was looking for a number that reflected the true gravity of what had happened, that acknowledged the harm caused, and that was high enough to mean something beyond a passing financial inconvenience. The negotiations were tense. Susan and her attorney repeatedly tried to frame the agreement as an honorable exit for both parties, as though Diana were doing her a favor by agreeing to close the case without going to trial. Diana did not see it that way, and her attorney was absolutely clear about what would happen if the case reached a jury with that recording as the primary evidence. The final number was $50,000. $50,000 that Susan would have to pay Diana as formal acknowledgement of the harm caused by her conduct on that October morning. But the agreement included more than money. It included a series of conditions related to Susan's future behavior within the neighborhood, obligations to participate in racial discrimination awareness programs, and clauses that made any future incident substantially more costly from a legal standpoint. The money was important. The conditions were even more important, because Diana's goal had never been simply to be compensated for what she had suffered. It was to ensure it would not happen again. The agreement was signed on an afternoon in March, 5 months after that October morning, at the mailboxes. Diana was in her attorney's office when she put pen to paper, and the people in the room described the moment as surprisingly quiet. There was no celebration, no dramatic relief, none of those cathartic moments that movies teach you to expect when justice finally happens. There was only the quiet weight of a long process coming to an end, and the awareness that no amount of money and no contractual clause completely erases what was done on that sidewalk on a Saturday morning. Diana gave an interview a few weeks after the agreement was finalized. She spoke with the same calm she had demonstrated throughout the entire process, the same calm that was recorded in that mailbox video, and said something that summarized with precision what had motivated her to see it through to the end. She said that she knew, from the moment she walked back into her house that Saturday, that if she did nothing, Susan would continue doing the same thing to other residents, to people who would not know there was a camera, to people who would not know what their rights were, to people who would not have the resources or the knowledge to fight back. She had fought not just for herself, but for every one of those people the system leaves without options. The video had already circulated among resident groups and civil rights attorneys before the agreement was even finalized. After the outcome became public, it began spreading in a broader way. People shared it not just out of outrage over what Susan had done, but because of what Diana had done in response. The way she had documented everything immediately, preserved the recording, filed the formal complaint, built the case with methodology and patience, and refused insufficient settlement offers until she achieved a result that truly meant something. She had transformed a humiliating experience into a manual for how to defend yourself when the system tends to protect the one who did wrong. Susan virtually disappeared from the social life of the neighborhood after the agreement was signed. Some neighbors reported that she had drastically reduced her interactions with other residents, that she rarely appeared in common areas, and that when she did, she avoided any contact with Diana. Whether she had genuinely reflected on what she had done or had simply learned to be more careful is impossible to know. What can be said with certainty is that the entire neighborhood had changed after that process. The association had revised its internal policies. The residents who had shared their own experiences during the investigation had finally seen their stories taken seriously. And there was a camera at the mailboxes that everyone now knew was recording. There is something deeply revealing in the way this case unfolded from the standpoint of what it says about power and about who has access to it. Susan had acted the way she did because, on some level, she believed she could. Because people in positions like hers generally can and usually face no real consequences. What she had not calculated was the specific combination of factors that made this case different. A camera in the right place, a victim with specialized legal knowledge, and a determination that did not yield when the system offered the easy exit of an insufficient settlement. Remove any one of those elements, and the outcome would likely have been completely different. That is the most uncomfortable part of this entire story. Because the truth this case leaves hanging in the air, after the money was paid and the documents were signed and everyone's lives moved forward, is that justice should not depend on a camera being in the right place. It should not depend on the victim being a specialist attorney in precisely the relevant field. It should not require months of legal proceedings, considerable financial resources, and an extraordinary determination from someone who had already been humiliated enough. It should be accessible to any person who wakes up on a Saturday morning, goes to get their mail, and is treated as though they do not belong in the place where they live. Diana achieved justice. But she was the first to say that the fact that she achieved it does not mean the system is working. It means only that this time, With this unique combination of circumstances, it did not manage to fail.
Integrity is a lifelong quest, and education remains your strongest asset. Thank you for tuning in and promoting institutional transparency.